Hello everyone, welcome back to part 2 of our video lecture on domain name systems and intellectual property rights in India. In part 1 we have already discussed the concept of domain name. In this particular part we will be discussing the interface between domain name and intellectual property. Basically, domain name attracts feature of trademark particularly related to the action of passing off and infringement. Another IPR interface which domain name have is related to copyright. First of all, let us understand what we mean by trademark. A trademark means a mark capable of being represented graphically and which is capable of distinguishing the goods or services of one person from those of others and may include shape of goods, their packaging and combination of colors. It is a distinctive design, picture, emblem, logo or wording affixed to goods for sale to identify the manufacturer as the source of product. Basically, trademarks are unique and any illegitimate use of a well-known trademark causes infringement of trademark under the Trademark Act 1999. Also, when a registrant tries to encash on the reputation of a trademark holder by running a business similar to that of trademark holder, then it also amounts to trademark infringement. What makes domain name different from trademark is the concept of counterclaims. Now, what is counterclaims? Counterclaims of domain name is that there are more than one legitimate user of a domain name. Apparently, there is no intention to trade off a trademark name and little or no potential for confusion between the products of the conflicting claimants are there. Both parties have a particular trademark of their own or a valid reason to use a particular domain name. For example, Moonlight Computers and Moonlight Dry Cleaners would be interested in registering the domain name moonlight.com. Cyber squatting. Now, what is cyber squatting? Cyber squatting occurs when domain names bearing a resemblance to famous trademarks are registered by person hoping to sell the registration to the corresponding trademark holder. Similar was the case of infringement in case of trademark also. Typically in such cases, persons who have absolutely nothing to do with the name virtually pirate the name by obtaining a second level domain registration with the top level domain of a well known company or a brand. There are currently no laws or statutes in India expressly prohibiting cyber squatting, also known as domain squatting, and as such, disputes surrounding these practices are mainly governed by the principles of passing off given under the Trademark Act of India. A very prominent landmark case in this regard is of Yahoo Inc. versus Akash Arora. Now, in this particular case, the defendant was restrained from using the word yahooindia.com or any other trademark or domain name that is identical or deceptively similar to the plaintiff's well-known trademark Yahoo. It was also held that the services rendered by plaintiff on internet has become recognized and acceptable globally and thereby though Yahoo is a dictionary word but it has acquired sufficient uniqueness and distinctiveness so as to enable the plaintiff to be protected against the passing off. Another similar case was of Rediff Communication Limited versus Cyberbooth and another. In this case also the defendant has registered the domain name radiff.com which is similar with rediff.com and the court held that a domain name is much more than an internet address and as such is entitled to protection to get protection equal to that afforded to a registered trademark. Similar type of cases were there, that is Titan Industries versus Prashant Kurapati and other. It was related to domain name registered by naming it Tanishq. Similarly, Dr. Reddy's Laboratory Limited versus Manu Kashori and Tata Sons Limited versus Manu Kashori. These are the landmark judgments in which the issue of cyber squatting was discussed. Another type of cyberquatting that occurs is cyberquatting with bad intention. A registration of domain name in bad faith when the registration was done primarily for the purpose of disrupting the business of a competitor. These are basically the unfair competition practices which occurs. A landmark judgment is infospace.com Inc. versus Hari Prasad. In order to resist an action under bad faith, a connection or a nexus between the mark used in relation to the goods and the person claiming a right to use the same must be shown. Cyber squatter is able to show a reason for registering the domain name other than to sell it back to the trademark owner, then probably the court will allow him to continue the mark. Now, Kirloskar Diesel Recon Private Limited versus and Maruti Udyog Limited, these are the landmark judgments in this particular aspect. The third form of cyber squatting is related to dilution. Trademark dilution doctrine is adopted by the court in order to prohibit the misuse of a well-known or a famous mark as domain name on the internet. For example, Sony.com for cosmetic will dilute the registered and famous trademark Sony Corporation for electronics. So dilution is again regarded as a part of unfair competition, and therefore since there is no specific statute in India which deals with such type of domain name dispute, it has been taken care by the trademark act, particularly by referring section 134 and 135 of the act. And there is this uniform domain name dispute resolution policy given by ICANN, which provides summary procedure to be adopted for resolving these type of domain name disputes. Tata.org's case and Philips India's case are landmark cases which has been settled through UDNDRP. Basically, these policies promote arbitration and mediation. Another component of intellectual property that is attracted in domain name is that of copyright. The domain names or the website are basically soaked in information, much of it with varying degree of copyright protection. Websites are a composition of materials often consisting of various words, graphics, audio, video that are expressed to the consumer as information content. These are the original creations of the creator, and therefore copyright is automatically attracted. Basically, section 14, section 51 and section 44 of the Copyright Act is there, which can accommodate domain name protection. The very first aspect here which we will discuss is about linking. Now, what is linking? The linking of a site is only like informing people about the presence of work and giving the address of the site where the work is present. It is the user's discretion to access the work by clicking the link. Nevertheless, the linking site is definitely aiding in the distribution of work. Basically, there are two types of linking. First is surface linking, another is the deep linking. Now, surface linking is usually encouraged by the website owner because it will give them maximum number of it. But in case of deep linking, it also steals the traffic from the link site's homepage and thereby decrease their revenue. And that is why deep linking is not permissible. It generates a conflict between the rights of the content owner and public interest. Unauthorized linking or linking with bad intentions is certainly not permissible. Deep linking will be violation only if the reproduction of work is there. Otherwise, it is not. The very famous case which is related to linking is Ticketmaster's Corp versus Microsoft Corporation. When we talk of Indian law, Section 2FF does provide us the provision under the Copyright Act that communication to the public, which means that making any work available for being seen or heard or otherwise enjoyed by the public directly or by any other means of display or diffusion other than by issuing copies of such work, regardless of whether any member of the public actually sees, hear or otherwise enjoys the work so made. So linking is supported under section 2FF, but if there is deep linking, then certainly it will not be permissible without proper authorization or written consent. Another form of copyright interference which is there with domain name is inlining. Inlining enables a web page to get different elements from diverse pages or serves to create a new web page. Instead of copying the elements to the composite page, the elements are linked by pulling in graphic or image field from another side and displaying on the composite web page. Thus, the composite page would consist of series of links to other sites and servers. While browsing the composite page, the page directs the browser to get the pictures, graphic, etc. from the original source. A very good example of it is like news, Google News, like news.googles.com. So that is there. Another type of copyright which is attracted in domain name is related to framings. Now, web browsers allow web authors to divide page into frames. Basically, a frame is an independently controllable window on a website through which pages from another website can be viewed. Since it is possible for a site to call a frame's content from a different location, a programmer might frame another's web content beneath his own navigation or banner. Now, this allows him to use creative content owned by another entity to sell banner advertising on its own website. The person who frames some other site content on his site is not causing any direct reproduction of the copyright content. This is because the framer never copies the pirated content. Instead, merely provides a visiting browser with instruction to retrieve the content, which is then incorporated into the overall page on the user's site. But in case of framing, the moral right questions are there, like question of attribution, question about integrity, question about dilution of work that needs to be taken into consideration. So when we talk of domain name and copyright, precisely we have to take into consideration these three sections. Section 14 of the Indian Copyright Act, which provides the rights of adaptation only to the owner of copyrighted work. Then section 51, which talks about provisions related to the infringement of copyright. We have to literally drill down and see that what sort of copyright infringement has occurred when we do linking, inlining or framing, and then only we can apply 51. And then of course there is section 57 which provides author special right about right to claims and right to integrity. These rights needs to be taken into consideration. Now, for copyright infringement, the remedy is provided under the Indian Copyright Act: civil, criminal, and administrative remedies. Criminal punishment along with fine, civil injunction, account of profit sharing, compensation, and administrative remedies wherein confiscation or depositing the copied content, and so such kind of remedies will be there. There are specific remedies also for online copyright infringing, and the court directs the infringing website to be blocked by internet service provider, either as a part of John Deere order or the website blocking. Now, this was done in RK Productions versus BSNL, or sometimes even selective blocking is there. So, these are the provisions of Copyright Act which are applicable to domain name disputes. If you like my video, kindly subscribe it, and if you have any queries, you can ask me on payal.mundafale@nagpuruniversity.nic.in. Thank you so much.